I'd like to introduce our speaker for this webinar, Shada Ramjas. Thanks for joining us. So Shada has been a family lawyer for 18 years, holds a master's in family law, and has been an accredited specialist in family law since 2013. Shada was a registrar at the Federal Circuit and Family Court of Australia. She's currently a senior solicitor with the Early Intervention Unit at Legal Aid New South Wales. So I'll pass it to Shada and ask her if she could please tell us a little about what topics we'll be covering today.
Thanks, everyone, and thanks for that introduction, Michelle. Basically, this webinar is a follow-up to one that I presented last year, which was called Essential Update: Parenting Matters in Family Law. At that time, the laws had an update, and it was really interesting to talk about what changes had come into place. And we said at the end that further changes were coming in 2025 in June, and that we'd do a follow-up webinar about those changes when they came in. This is that webinar. So basically today, what we're going to do is just talk about what the recent changes are, what those June changes are, how that really will affect your clients, and how it's potentially going to affect what you do in your work, as this is a seminar that's being created for the community workers today. And although I do know that when we had registrations, there were a couple of lawyers in the crowd here today, as well as a lot of interpreters, which is excellent to see. And so it's really great that we've got such a great broad spectrum of the family law family here joining us today. So really just want to focus on what those recent changes are and what else we can do, as well as answering any questions. So as I said, last year we did an update on parenting. So those changes that came to effect in May 2024 really were pretty varied, but they mainly focused on parenting issues in family law. So we looked at last year in a webinar, which is available on YouTube and which you can go and see, and I'm not going to cover again today because you can go and watch that webinar. But we looked at parental responsibility decisions, basically how the court decides what is in a child's best interests when making orders about children's arrangements, looking at how independent children's lawyers work and rules for family report writers, how information can be shared between the child welfare agencies and the courts and police and things like that, so that safety information is shared really quickly. Looking at the processes for what happens when a party doesn't follow orders. And I know there have been a couple of questions about that already, or when someone keeps bringing cases back to court. So we did address that in the last presentation, as well as looking at the issues about what happens when someone publishes or posts online about a party or a case, which is not allowed, definitely not allowed to happen. So we looked at that in the last presentation, and you will get a link after this webinar is concluded. You'll get a link to both this webinar and the previous one. So if you wanted to go back and look at any of those issues, you definitely can. But as we said, one of the things that we looked at last time was what is in a child's best interests. And that's a summary of Section 60cc of the Family Law Act. So it's very important, but it's not something we're covering today. So I will send you the fact sheet that we wrote up about that too, as part of the links that you're getting in the email today. There are also going to be some really great links to some great resources. A lot of things have been published by the Attorney General's Department, including fact sheets in other languages, which is really helpful, especially for all our interpreters there. I know you'd be really interested in seeing that. So those are some of the links that we're going to send you, but I'm not going to cover those things today because today is about mostly focusing on property, on the more recent changes. So with the next slide, I'll just say, what we did last time was we talked about what kind of happens when a client first comes to see us. So in my day job, I work for legal aid as a duty lawyer. So I'm on duty at the courts, and people usually come in to the courts and say, I don't know what to do next. What should happen? So on that next slide, you'll see we've talked about what happens sort of in the first 10 minutes of a client coming in, basically. So we look at whether the case is actually about child welfare, so that's a state issue and it's different for each state, or family law, which, as Michelle said, is a federal issue. And most times people need advice about sort of divorce, parenting, property, and things like spousal maintenance and child support. So today we're talking about property. We're also going to look at the options for what happens keeping things out of court or once court is finished, the kinds of informal arrangements people can have and what to do if things are not being followed, arrangements and agreements are not being followed. But also, when a lawyer first speaks to a client, we're going to be looking at what other kind of legal advice someone might need. So whether it's tax advice, immigration advice, criminal law advice, your family lawyer might not have knowledge of all of those different areas. So they might be referring clients to get different advice from those kinds of specialist lawyers as well. But we're also going to be looking at non-legal advice. So a lot of the audience here today are community workers. We're probably going to be thinking about what kind of referrals we can make to you for support, financial advice. There are a lot of financial counselors who have registered today, which is great to see as well. Speaking to an accountant, working out the finances is really important to get proper advice right at the start, rather than try and wedge it in at the end. But like I said, we'll also be talking about getting counseling, because family law separation is a really hard time for our clients. We all know that. But one of the other important things we're going to be looking at is whether we can do some safety and risk planning, and if we need to make referrals about safety considerations as well. A lawyer is also going to be looking at how a client can pay for what assistance is needed, whether they're able to fund their case privately, whether they may be eligible for legal aid, whether other services like community legal services or limited retainers of limited work being done for someone to pay for just a small piece of work might be appropriate, or whether a client might be looking at doing the work that's needed by themselves. So those are the kinds of things that a lawyer is going to do when they first see a client. In our situation, though, let's imagine that you're sending a client along, and really we want to focus on property. So what happens when you're dealing with finances? So that's what we're going to focus on today, because that's the bulk of the changes that came into effect in June. So before we dive into property, though, I wanted to just sort of set the scene. So on our next slide, you'll see what we've talked about is the arrangements that have sort of come into place since the courts themselves have changed. So you'll find clients who you may have helped in this area for a long time and helped them when they were dealing with the cases in the Federal Magistrates Court or in the Family Court. Well, since 2021, the Family Court and the Federal Circuit Court merged, and they're now called the Federal Circuit and Family Court of Australia, FCFCOA. Sounds a little bit like focaccia, like a bread, but it's not a bread, it's a court. And so the court's website is where you'll find a lot of really great information. But when your client talks about filing paperwork on the court's online court portal, that's actually different from the court's website. That's called the Commonwealth Courts portal. So we've just put both of those up there just so that you're aware of them. You don't need to do anything about them, but just so that you're aware, when clients say that they can't get their court orders or what they need to do next is not clear, there actually is a separate website that they might need to be looking at. So I just mentioned that for you to know.
Very helpful. Thanks, Shada.
No worries. So the next slide talks about basically the other changes that have come into the court. So particularly changes in technology. So since that merger in 2021 and since COVID lockdowns were happening around that time, a lot of the court hearings went online. And since we've come back, a lot of the hearings are still online. So your clients may not be aware that they don't actually physically have to come to the court building for quite a lot of their court case. A lot of the times the final hearing is in person. So that's when they're actually going to come into the court building. But before that, most of the directions, most of the checkup dates, most of the online mediations and so on that might be part of the court process are usually through online services. So for most things now with the court, it's WebEx. It used to be different accessibility portals might be there as well. But for most things, it's now WebEx, which is an online link that people will get emailed and that they can click on to get into their court hearing. So that can be quite a different change for people. It's really good for clients who have been remote or who might have accessibility issues or responsibilities,
Definitely.
which mean that they can't travel away from home easily. It can also add some safety issues for clients, though. So these are just things for you to think about when you're supporting your clients. One of the other things that's changed with technology is that the court itself has tried to streamline a lot of its forms and guided processes for people when they're filling out their own forms or when lawyers are filling out the forms online. So there are guided processes. They ask for you to upload things and type in things at certain places. Some of it is a bit repetitive. That's just the nature of forms, unfortunately. But these are just things that it's good for you to know about. So the court has tried to make things a bit more user-friendly and directive for clients who are especially dealing with these forms themselves. But I think it can still be a little bit confusing for clients. So you might still need to refer them to get some legal advice as to how to actually fill in or what it is that they should be asking for when they do those applications. It's important to know that the court has also been trying to make the way it deals with cases, especially property cases, a little bit clearer for people. So the kinds of cases where what we might call a small asset pool, I think talking about $500,000 as a small amount of money might sound a little bit strange. But when you're talking about equity in a house in sort of, and Michelle, you did mention this is New South Wales legal aid, so we're sometimes looking at Sydney city prices, and
Absolutely.
house prices are always just going up. So,
Cost of
if there's,
living.
that's right. And so where you might have bought something that was not worth very much money for a very little deposit with a huge mortgage, just the fact that the value of that land has gone up might be bringing in a lot of equity in a relationship in a short amount of time. So we talk about small property pools, that's under $550,000. There's a sort of streamlined fast track process where the court is trying to make sure that people don't spend most of that money on lawyer fees or just waiting in court to get their settlement done. And there are special lists as well where they're putting all the cases together to hear where there are very large pools. And so that's sort of $20 million plus. That's money outside my price range, but it's good to know that that exists as well. So another thing that's important, I think, for caseworkers to know is that court orders are no longer mailed out to clients. They are put online on that Commonwealth Courts portal. So if a client says, I don't have my orders, or I need my divorce order, or I don't have any of these things, it can be quite stressful for them when they think, oh, I have to go into the court building. I might have to pay a fee to have them print this out. You can tell them you don't actually have to do that. They can log into the Commonwealth Courts portal, that online portal that the court has all of its systems on now, and people can download their orders for free. But that can be difficult for people who have technology issues.
Absolutely.
So, yeah.
That's a really helpful tip because always we receive things with paper,
Yeah.
and we're joined by a lot of community caseworkers, and just having that practical to calm clients and let them know that you can help them if there's those technology hurdles. Thanks, Sharda. That was right on for who's joining us today.
Well, I think it's really useful because you don't have to be a lawyer to join onto the ComCourts portal. So if you're helping a client and they've got permission, you've got permission to help them and you've got the time to do this, you can actually help them by just logging on, just as you would log on to an email account. And it doesn't have to be at one computer. You can do it so long as you've got the password and the login details. You can do that at any time, and then you can help clients sort of go through what's there.
I think we've got, oh, sorry, Shada, we do have from our attendees, we do have, talking about that digital disadvantage and some of those accessibility. So they are changes, but potentially as people that are working with clients, we can help them through that potential hurdle that makes it easier for some, but a little bit more difficult for others.
That's right. And there was another question about security processes. Well, I can say there's a lot of passwords and things you have to put in. And to tell you the truth, I often warn clients that they might be logged out frequently and have to re-log in frequently and have to put in all their details because the system is trying to be so secure that sometimes I find it a little bit annoying because
of course
it's a government system that is really quite basic in its structure. So it's not, pretty flashy pop-ups and things like that all the time, but just sometimes you have to keep logging back in, making sure that all the security things have been done, and it's for security reasons. So
and that's good to share because people might think this is me, but it's actually, this information that clients and caseworkers are putting in, potentially their children's names, their assets, very, very, we want that treated securely. So a little bit annoying, but ultimately big picture, very important.
Very much so. And the other thing I was going to mention was we talk about less adversarial trial processes in relation to parenting cases often. So that's trying to make things a little bit less formal. Well, no, I shouldn't say that. It's still a formal court process, but it relaxes the rules about how evidence is given and what order things should happen in, and whether people can give evidence in different ways, especially when there's family violence considerations. People might feel uncomfortable being in the same courtroom, whether they can give evidence remotely through technology. That less adversarial trial process applies for parenting cases very frequently, and it's really easy to sort of see how that works. It can also apply for property cases now since the changes. It used to be able to be applied previously as well, but it's just clarified that that's really a pathway that can be applied by the court. So I think that's useful to know as well.
Definitely.
But I really want to get into talking about the actual changes. So with the next
Yes.
slide, we talk about
Let's hit the big changes.
that's right. So the laws that changed on the 10th of June, they are pretty much the biggest changes to how family law deals with property division, property settlement since 2009, when the laws changed to allow de facto couples to have exactly the same processes as married couples when it comes to dealing with property division. And one thing I think is worth noting is that when we talk about de facto couples, people seem to have this idea that you have to be together as boyfriend and girlfriend or as a de facto couple for 2 years before you can use the law to deal with financial settlement. That's not true. A de
Really?
facto couple is not just 2 years. It's you might have a child together and be less
Of
than
course.
2 years together, or it might be that you've just shared money together, that you've held yourself out as a couple in the community. There are a lot of different definition factors that come into it. It's not just a minimum of 2 years. So don't think that if a relationship hasn't reached 2 years for your client, they don't have any resources available to them. They absolutely do. So definitely get them to get some legal advice. Now, with these changes, so these recent changes, 10th of June 2025, we've got all of these new changes in property law, and people have asked, my orders were made last year. Does that mean that they should change now? No, they don't. Once they're made, orders are
Oh,
made, and
good.
that's final, and that's it. But these changes will apply to all cases that start now, all negotiations and settlements that happen now, as well as anything that had started before but hasn't reached a final hearing in the family law courts. So a final hearing is the end point where a judge is making a decision to end the case and all the things are going to be finished. Sometimes those cases start but get put on hold and paused because they run out of time or they need to have an adjournment for some reason, and it's going to be picked up again later. If a case has started under the old law, then it's going to finish under the new law if that was the final hearing. But if a case has started and it's not been a final hearing, so it's just been in court a few times, but the final hearing hasn't been reached, when the final hearing comes and from now, the new law is going to apply. So,
Okay. More changes.
yes, well, so drilling down into what these changes are, basically, there was a process for dividing property. We used to talk about a 4-step process, but it was never
Yeah.
written down. It was something that judges applied. It was something that lawyers knew about. It was something that we all talked about, but it was never written down into the law as to what steps they were and how that should be taken. Now that change actually puts it in the law so that people can see exactly how these steps are going to be taken. There's family violence consideration. So family violence was always able to be considered as a part of how a financial settlement should happen, but there were a lot of threshold issues and it was a little bit difficult. Now the law has actually been updated so that each step of the court's considerations can take that into account. And we talk about what family violence is, what the definition is. They've added in to just make it clear that financial and economic abuse are types of family violence. And they put in some examples, which are really interesting examples, such as dowry abuse. The court has also now got specific instructions about the kinds of orders it can make about pets. So we call them companion animals, but basically what orders can be made about pets who are not considered to be children, they're considered to be property. And there's also some pretty significant changes in the law about financial disclosure obligations. So all the time you used to have to give full and frank financial disclosure, meaning you have to give all the information about your finances when you're dealing with a financial settlement. It used to be in the family law rules that this is what you had to do, but now it's part of the Family Law Act. The actual words of the law include that responsibility to give all that disclosure. There are some other changes too, which don't really count as property changes, but I think they're very interesting to cover. So I know a lot of people joining us work with agencies that have children's contact centers. So one of the new things that's going to come in is new accreditation rules about the children's contact centers. I think it's really relevant for you to know as caseworkers that there are a couple of minor but important tweaks to divorce law that have come in as well. So it used to be that when a marriage was less than 2 years, people had to attempt counseling, get a counseling certificate, or explain why they couldn't before they could get the divorce granted. That's out of it now. There's no longer that requirement. And it used to have to be that people would have to attend court, previously in person, or since the changes, it has been by telephone. They used to have to attend court if there were children under 18 to give an explanation about their care arrangements. That's no longer required now. So unless the court states that someone has to attend for a divorce or a party requests it, there's not going to be a requirement for attendance, which can be really, really a big deal for people when they're applying for that divorce process. Now, another change, and this one's very interesting, is that under a Commonwealth Information Order, so that is our courts have the power to ask a Commonwealth agency or a department for information, and it used to be about a location. So for example, if a child was taken and no one knew where they were, you could ask for information about where the other party was, so that you could start court by serving the documents on an address that was given, for example, or things like that. So the court can actually request information about a location, but it can also request reports about actual or threatened violence about anyone connected with a child now. So this is a really big change. Commonwealth information orders can give quite a lot of information in a family law case. That's a very interesting change, I think. And particularly for our audience here today, there are new protections about sensitive information. So counseling records and things like that, protecting that confidential information so that it doesn't cause harm to your clients. That's really interesting to look into too. So it doesn't quite fit the category of property, but I think it's good for you to know about. So
very much so.
As we go to that next slide now, you'll see one of the things that I think drives these changes. So the parenting changes last year, these property changes, and other changes this year. Family law has really been changing to try and respond better to cases where there's family violence, because we know that that's a really relevant piece of people's relationships in some circumstances. And I don't think we've always been able to address it or acknowledge that openly. And so the changes in the law are trying to make sure that what people often are afraid of bringing out or are worried about discussing is actually given a bit more of a highlight and understanding, so that we can talk about what impact family violence has. We should know what the definition is. Under the Family Law Act, we're looking at it as violent, threatening, or other behavior that basically coerces or controls a family member, or it causes them to be afraid.
So Sharda, just to ask, because we've got some questions. So, you know, this does have the intersection of the new coercive control laws. Fantastic.
So
that's good to know for our community workers.
Yeah, those laws have been state laws, so they're new laws that came in. There are only a few prosecutions under those new state laws, but that's because part of the behavior that looks at coercive control, part of that change in the law is that the behavior has to have happened since the law came in last year. Of course. So that's a state-based law. But the thing about family law that people don't always realize is that you don't need to have a criminal conviction for family law to consider a family violence experience. Often what happens in a relationship is there are two people and there are no witnesses to what happened. And often what happens in a relationship is that people might not be reporting or telling other people what's happening in their private relationship. So there is no external evidence sometimes, but sometimes there is. Sometimes there's things like people have gone to the doctor and they've mentioned things to their counselor.
Or our community workers that are joining us today. Absolutely.
Right. So these are the things where I think empowering clients to understand that, you know, whatever has happened to them, whether it's left a bruise, whether it's left a psychological impact, those examples that we've put up there on the slide talk about, you know, things that you might imagine: physical or sexual assault, stalking, taunts, so putting someone down all the time, property damage, things like harming or killing an animal to keep someone under control, economic and financial abuse. That can include things like not allowing someone to have their own money, or to earn their own money, or to manage their money for the household and have things taken away from them. Preventing connections with family and culture, that's also a form of family violence. And deprivation of liberty, or that financial autonomy, that ability to actually stand on your own 2 feet and look after yourself financially. If that's impacted, those might all be examples of family violence that the family law considerations can take into effect.
And would some of that family violence be more expanded on our other webinar that you did in Law Week?
Oh yes, that was also a really interesting. A lot of interesting questions came out at that time as well. So we talked about that.
We'll put a link into the email afterwards for that,
That's right.
Shada.
There are a lot of really
Really
great
enjoyed that
resources, and
webinar.
we're going to share a lot of resources with you
Yes.
after this webinar is concluded.
Okay, we might move along.
Yes,
to the practical.
Really want to dive into this part, because I think for a lot of people, you kind of say, okay, this is all nice theory, but how does it apply in practice?
And
what do we do? What are the steps? Well, here are our steps.
Here are our steps.
So Michelle's helped a lot in making these slides beautiful. And I think these are really great graphics to help you understand exactly what happens. So we used to talk about a 4-step process, and you can see there are 4 steps here. But the thing is, you can mix and match these steps. And what the courts have said is that mostly you start by looking at what the assets and liabilities are. You consider what parties' contributions are. You adjust those percentages to take into account current and future needs, and you make sure the whole process is just and equitable. But sometimes you might reorder these steps. And the fact of checking whether things are just and equitable, basically whether things are fair, you might be taking that step all the way along as well. So we kind of talk about 4 steps, but really it can be flexible. But these are the things that we're going to focus on. So let me tell you all about them.
Okay, we'll just go over to the first, well, one of the steps.
Yes. So usually this is our first step, working out what's in the asset pool. So as a lawyer, I realize that I say property settlement, we're dealing with property changes. Property for most people in normal life just means houses, but for lawyers, it means all the financial stuff. So it means homes and cars and cash and investments. And investments can be, both land and shares, but also it can be, gold, jewelry, cryptocurrency. We also include superannuation into that. And now that can be quite a hefty amount when you think about it. We look at savings, businesses. So a lot of people have a family business or a side business, or might operate as sole contractors or have a big business. You never know. All of those things will count. Look at furniture and pets. Also look at all the debts, the mortgages, the credit cards, loans, and sometimes borrowing from businesses or from family. But sometimes those loans are not real loans. So sometimes you have to check what documentation is there. This is all where it gets really complicated. So we're looking at all the things of value, all assets and debts that is owned by each party, as well as jointly with other people. So jointly with both of them or with other people. So for example, if you've bought a boat with your uncle.
Parents?
Yeah. That your share of that comes into this asset pool here. And so where you have extended family structures which share money, that can get really complicated. When we're looking at the asset pool, we use current values. A lot of people are really shocked. They say, oh, but when we separated, the house was only worth $1 million and my super was only 200,000, but the market's gone up in both senses. And now the house is worth 1.5 and super is worth 2.5. That time of separation value is not what we're looking at. And what you bought the furniture for is $10,000 worth of furniture at the time you bought it. Currently, you couldn't give it away on Facebook Marketplace. So we're using current values for things. And so that's sometimes a bit of a shock for people. We're looking at
definitely.
We're looking at assets that are both Australian and international. So things that are held here as well as overseas in any person's name, including joint names. And a lot of time people ask, but what about when money goes missing? So
we do have some community questions about, wastage, gambling, giving money away. So
well, that part I'm going to. So first of all, if money is missing from where it should be, as in money is being taken out. So in a bank account, if you had $50,000 in a bank account and then someone used that money and bought a car, now you've got $50,000 worth of car. So the money hasn't gone, it's just changed shape. So you include that thing that got bought, that car, now comes into our asset pool instead of the dollars. Now, Michelle, you mentioned wastage. That's actually a really good point to mention for that next step. So first step is working out what's there, the asset pool. Then we usually look at the next step of contributions. So looking at what each person brought in. So this is the part where people say, but before I even got into the relationship, I had my own house. I brought that in. Or
Absolutely.
I had this, superannuation saved. Or what happened after the relationship is that then someone passed away and I got an inheritance just last week, and that's a whole year after our separation. So these kinds of contributions, what each person brought in, kind of get weighed up. So at the beginning of the relationship, what did each person have? Was there a lot of debt from one person? Was there a lot of savings? Did both people have mostly the same kind of stuff? We look at financial and non-financial contributions. So contributions can be in kind. For example, if you had a client whose brother was a plumber, and so when it came to renovating the bathroom, instead of having to pay $20,000 or more to renovate the bathroom, your client's brother did it for free. That counts because that $20,000 additional value comes on their side of the ledger now, because that's added value. It's a contribution on that they brought in. So you can have contributions that are made in kind, made by the party themselves or on behalf of the party, before the relationship, during and after. And like I said, both financial and non-financial. So going out and earning money to pay the bills and pay the mortgage counts just as much as staying at home, looking after the kids, looking after the home, inside and outside chores. But we can also consider those negative contributions. You mentioned, Michelle, wastage, debt, taking out loans, gambling away money. I think as well, also just paying money overseas, taking it out of the asset pool and giving it to other family members. Those things can be counted as contributions, positive and negative contributions, and also the effect of family violence. So if family violence has impacted a party's contributions, they might not have been able to work and put in as much, or it might have impacted how they can actually contribute.
That's answering quite a few people's questions. Thank you,
I saw that,
Shada. And
yes.
just to reiterate, thank you for clarifying that, those non-financial contributions like looking after children or the household are in there, because there's been a couple of community workers or people that are joining this webinar that definitely are wondering about that. So thank you. Should we move on to another step?
The future needs of a party.
There we are.
Okay,
thank you.
So the future needs, basically, well, we used to call it future needs, but the language in the act that has just come in actually says we're looking at the current and future needs of each party. So what we're looking at here is, are both parties able to meet their current and future needs in the same way? So for example, if in a marriage that was, say, a 20-year marriage, at the beginning of the relationship, maybe both people had been, starting their careers. But over the course of 20 years of relationship, if one person was no longer going to go to work, say they were going to stay home, look after children, look after the home, and the other person was focusing on the career. And so one person's career has been really supported and developed, and the other person's career has kind of just canceled, not gone anywhere. After the relationship ends, one person's got a really great resume and a history of work behind them, and they can earn at a different way, and they can get a job for a different salary than the person who's been out of the workforce for 20 years. So you're looking at really what position each party is in now. So if you're making arrangements about parenting at the same time, parenting responsibilities may or may not impact a child's needs. So if you've got a kid who needs to be picked up from daycare at a certain time every day, you might not be able to do the 9 to 5 in the normal way, where you have to be stuck at work and you can't get out to deal with that pickup or drop off time. So you might be choosing a job that allows you to be more flexible, but then that job might be a lesser pay scale. So these future steps, these things that are going to impact what each person needs and how well they can meet those needs, looks at kind of things like working capacity. Do other things impact that, like parenting responsibilities or health? So if someone's got expensive health conditions, do they have to pay money for things? Are they also going to be unable to work? Has family violence impacted their health? both emotional, both physical and psychological. Age differences. So if someone's got a really long working career ahead of them, they're going to be able to earn money and look after themselves in the future. But what if someone's close to retirement? Maybe they'll actually be able to access their superannuation or get a really valuable pension potentially, depending on their working conditions. So they might be able to get a lot more money that the other person would not be able to access shortly. We look at financial resources. So that's things like, is an inheritance likely to immediately come to someone? So whilst someone might have be a beneficiary of a will, you never know when that might actually take into effect. But if someone has had a family member pass away and you know that the will says that money should come, but it's just taking time to get through the courts, is that almost their money going to be part of this case? Sometimes people might have, a workers' comp claim or a car accident claim that's going to take a few years to get sorted, but eventually some money is likely to come from that. So these are the kinds of things where we can look at what kind of resources people have and whether those things should be added straight in at the asset pool stage or not. And we are also needing to take into account the impacts of family violence on people's current and future needs too. So taking that into account, we looked at what's in the asset pool. We looked at what are the contributions. You might adjust for some of those reasons, like one person needs more now because they can't earn as much for themselves at present. And then we come to that last step, which
and
is
we're up with a step.
yes, dividing that asset pool. So basically we've got our asset pool, which kind of looks like a balance sheet. It's all your assets and all your liabilities. It's all the stuff that exists. Then you have to divide it. So whatever percentage we've reached, and people talk about 50-50, there is no automatic 50-50. People say, oh, look, one person gets everything. No, there's usually not 100%, 0% either. Usually it's somewhere along the line. No lawyer is ever going to say you're going to get 36.7% and the other person is going to get, 63.3%. I don't know if I've done my maths right there, but, basically how this works is that the court doesn't have a calculator that it plugs in a formula. It's going to take into account those steps. So working out what's there, looking at those contributions, looking at the current and future needs, and then working out how to divide that in accordance with that percentage that's worked out. Has to be just and equitable at each step. And this is where we have to really reality test. So your client might say, I want to keep the house. Well, that's clear. But if your client is not working, the bank won't give your client a mortgage. So they can't keep the house if they can't pay it out potentially. So these are the things you have to think about. When you're dividing up there, you don't want to divide each thing. You don't want to get half a car and half the super and half of the value of the house. If potentially you might have a really high salary, you are able to meet those housing needs in a different way. You might be able to pay a lot of rent, but the other person might have a very low salary. They might not be able to live in super. You can't eat a share portfolio. You might need to actually consider exactly what happens at this stage. And that's where it's really important for clients to get financial advice. If they have complex business and trust issues and things like that, it might be an accountant. If your client has very little, I would strongly recommend you send them to get advice from financial counselors who are amazing and can really work with clients to be practical about what they need and how they're going to meet their expenses and how they can budget and plan for what's needed. A lot of clients feel a lot of shame talking about money. They feel like, oh, maybe I've got a job, so I shouldn't be able to get some assistance. There is a lot of assistance out there for people. Help your clients to feel empowered, to not be ashamed and to speak openly about the help that they need, because this is the stage where they really need it.
And a shout out to some of our financial counsellors that are joining us today.
Yes.
You do a great job.
Absolutely.
And, I think it's National Debt Line where you can just Google and find a financial counsellor near you.
Yeah, a really excellent service. So
Okay.
I wanted to talk then a little bit more about family violence. And the slide that we're on now, the one about economic and financial abuse being explicitly recognized as a form of family violence is, I think, a really relevant one, because the economic effect of family violence can be crippling. And it's very hard for clients to sometimes recognize that this is what's happened to them. And even if they do recognize it, it's very, very hard for people to talk about. There are a lot of feelings of guilt and shame and cultural impacts, what is my community going to think about when I say these things out loud about people. There's a lot of things that clients feel really, really worried about in raising these issues. So I want to help you, the audience that's watching now, help your clients feel like these are things that they should be raising with their lawyers when they speak to them, and understanding
Definitely.
that this is important. Yeah.
And in the interest of time,
Yes.
we might go to the next slide, but we do want to assure you that we will be sending links out, and we'll be talking about how to get in contact for legal advice for your clients. But I know that there's an area of law that is quite unique that's made a change in the next slide.
Yes. So what I wanted to say was, when we're talking about family violence as a concept and financial and economic abuse, the Family Law
Absolutely.
Act now actually lists types of financial abuse, like the kinds of things where if one person is trying to work and the other person just doesn't pick up the kids, forcing them to have to keep leaving work early, which might mean that they get fired. That's denying someone financial autonomy. Another thing that's actually specifically mentioned is dowry abuse. And given the opportunity of doing a webinar, I thought to myself, look, a lot of caseworkers here have an understanding of dowry, but some might not be familiar with these concepts. So dowry is actually the word that's given to a really common gifting practice. Like a bride's family, usually when in a lot of Hindu marriages, a bride gets married, the family gives gifts to the groom and groom's family as part of the traditional celebrations. This tradition can be warped and exploited. And so that's the concept of dowry abuse, which actually has led to brides being harmed, hurt, and sometimes killed overseas, and sometimes in Australia, because their family hasn't paid enough or doesn't keep paying ongoing dowry expenses. So that's a really underreported area, but it's
And
a
it's
really
really
serious
great
area.
that we're getting some, changes in response to the makeup of our society.
And it's a very unusual thing that this is mentioned in the Family Law Act as a
Mm,
specific example of financial and economic abuse, of family violence. But I did want to point out that whilst a lot of people would consider a dowry to be a sort of Hindu practice, the word dowry, especially for all our interpreters out there and for the caseworkers who are going to be addressing multicultural communities, dowry doesn't always just mean that practice. A lot of people use the word dowry as a translation when there's other cultural practices. So, for example, and forgive me for my pronunciation, but I believe it's meher. It's a promise payment in an Islamic marriage contract where the groom pays the bride an amount at the time of the marriage and potentially in the future as well. And there are some cultures where we talk about bride price, but if you say I'm buying a bride, that's effectively slavery. So we don't use that word.
absolutely.
They would say dowry as a translation. But in those communities, often livestock, cattle or gold or cash might be paid to a bride's family at that time of negotiating the marriage or at the time of the wedding. So these are all really interesting concepts. And it's really
Definitely.
great to see that Australian family law is reflecting the multicultural makeup of Australian communities and societies. And so I think that's a really interesting new part of the law as well. But
Very
as
much
you
so.
said, we've got a lot to get through. And the other
We
really
do, we
interesting
do.
part,
We might bounce to potentially the cutest
yes,
slide.
that's right. So the other really interesting part of the changes is about pets. So pets are kind of a special category of property. We call them companion animals. So that doesn't include assistance animals, because basically a guide dog is not a pet, it's your eyes. And
Mm,
so we also don't include farm animals. So if you've got a flock of sheep, that is not a pet, they are livestock. So we're talking about companion animals, basically pets. And the court will consider who purchased the pet, if there's any family violence in connection with the pet, who that pet is connected to, and other relevant information like that when making orders about pets. It used to be that sometimes people would put in place orders about pets having shared care arrangements, just like children. But pets are not children. Under the law, pets are technically property. And so the courts can only make orders now when it comes to pets about selling a pet. So transferring ownership to one party or another party, or someone who's outside of the court case but agrees to take the pet, or that the pet must be sold. Those are the only orders the court will make now, not shared care. And it's interesting that the research shows that pets don't generally do well with shared care. They don't cope with a lot of changes in their living arrangements.
Interesting.
So yeah, we're going to add a link to that really interesting podcast that Legal Aid had about domestic violence and pets. So we'll send that to you later as well.
And a great initiative, Lucy's project.
Yes.
Okay, we'll get to the big, bold writing of
Yes.
dates and
So
action.
that's right. Time limits are really important. So when we talk about parenting arrangements, the court can make orders about kids until they're 18. But when it comes to finances and property, it's really important for you to know that your clients have a time limit. The clock is ticking. As soon as they're separated, if they're in a de facto relationship, it's 24 months. And for married couples, as soon as the divorce order is granted, the time limit is 12 months. Now, it's important to know you can't get a divorce right away at separation. You have to wait for 12 months of separation till you can apply for a divorce. So effectively, it's the same 24 months for both. But for married couples, 12 months from the date of divorce. De facto couples is 24 months from the date of separation. And after that time, what each person has is in their own name and is kept to themselves. You have to ask the court for special permission to bring a case that's outside of those time limits, and the court doesn't like to give that permission. So you really want to make sure that if your client tells you, oh, my ex maybe got a lot of money and I have nothing and I'm feeling it's really difficult for me to meet these cost of living pressures, definitely get them to get some legal advice as soon as possible, because those time limits might be kicking in really quickly. So it's really, really important for you to help clients meet those time limits and be aware.
Thanks, Shada. Yes, a very important thing to keep. We might just duck over to the next PowerPoint and the next couple, because I think the big thing that our participants want to know is how to get to us. So we'll go to the next slide.
So
we'll
this is
just maybe
to
touch on
say,
this.
yes, just to say quickly, make it legal. A lot of people think that a handshake agreement is fine. It's not. When it comes to property, if you haven't got something legally binding, which is either court orders or a legally binding financial agreement, which is something that has been written up and stamped by the court or written up and signed up with lawyers, if it's not done legally, it doesn't exist. And your client's ex-partner may come back and make another application once your client is building back their future. So make sure that they make it legal. That's really, really important.
Okay, we'll jump over. We have talked about full and frank disclosure, but there's a little bit more that you wanted to add to that.
Well, just that a lot of people are worried about what happens when their partner hides money or doesn't tell the court or doesn't tell them when they're negotiating, because you can negotiate outside of court. It doesn't have to always have lawyers in court involved, but lawyers are helpful. Court is optional. But a lot of the time, when it comes to dealing with what happens when someone is hiding money, there are potential really serious consequences in court. So cost consequences, punishment for contempt of court, which can include fines and going to jail. And the court can consider if some person is lying or hiding information about what they've got. When it comes to dividing up what's there, the court might take that very much into account when dividing up that percentage. So really important for people to know that things can be done about this.
Okay.
Now, the next slide is basically just a little highlight for you, especially for our counselors in the audience. Protected confidences from a client's treatment at a health service or a specialist family violence or sexual violence service can be requested by the court. There are ways to prevent that being used or limit its access. So definitely get some legal advice about that. And we're going to send you out a really great fact sheet from the Attorney General's Department and some webinars that have recently been done by Legal Aid, which highlight what to do when your notes are subpoenaed, which I think is really relevant for our audience here today. But as Michelle said, we've got that question and answer slide. So I know that people have been putting through a few questions.
You have actually answered quite a few of them, Shada. We've just got a couple that, just to drill down.
And I think some people are actually typing some questions now. So whilst they're doing that, what I might do is actually just go to the next slide, because I prepared this one from a question that was asked earlier, which was basically, how can support workers help their clients dealing with family law cases?
Yes, okay, I've attended the webinar. I've got all this in my head and floating around. What now that I've got a client sitting in front of me?
Right. So my advice, I am a lawyer, and I really think that legal advice helps everyone, especially if you can get some advice early. It doesn't mean that you have to hire a lawyer to be ongoing and run a case, but people really need to know their rights and what's important. So when we talk about what caseworkers can do, you can help clients get that advice. If you want to sit in on an appointment with a client and they let you, that's not a problem. But we will not be sharing that information. Lawyers have to keep lawyer-client confidentiality. And remember, you're a mandatory reporter, but lawyers are not. So we might want to ask clients questions about things that you might have to report, but we don't have to. So we might sometimes ask you to sit outside. Clients might say to you, I told you my story, you tell the lawyer. We don't want to hear it from you, unfortunately. We want to hear whether the client is able to actually tell their own story. And we might have additional questions or interpretations from things as well. So that's just something to bear in mind. The other thing, that next slide that you brought up, Michelle, is not actually relevant to property law, but something I always want to tell caseworkers. If you're not a silent elector, anyone, your client or your client's ex, could look you up on the electoral rolls. So
what we'll do is we'll put a bold link to that there.
Yeah. And I really
we'll just
recommend that people consider that.
Yes.
But I think the more important thing is this slide here. So if you need to get some legal advice for a client, what do you do? Well, Legal Aid is the first port of call, and we can give a lot of free information and advice and referrals to the other services that are needed as well. If someone's not eligible for legal aid, they might be eligible for a short advice session or some information which helps them go to speak to a private lawyer or take some steps for themselves. So we deal with all kinds of law. My specialty is, of course, family law. So that's what we're talking about today. But family, criminal, civil law, we do advice by telephone. We go to the courts. I'm a duty lawyer, so helping people at court who don't have a lawyer. We can fund ongoing cases as well. And Legal Aid has many tests. An important note to note is that legal aid can still help. Even if one person has legal aid, different parts of legal aid are firewalled and separate, so we can still advise without having a conflict. And with that next slide, you'll see that the services at the court also are available as duty lawyers for people who don't have a lawyer, but also with men's and women's support services, which are really, really helpful for people.
Everyone at the court. That's fantastic. Right. Thanks, Shada.
So the next slide is about if there's an emergency situation. So I said I'm a duty lawyer. I help with emergency situations like where kids are about to be taken overseas, underage forced marriage, stopping children from flying out of the country. Emergency things might be happening for your client. When that happens, you need to get them urgent legal assistance.
Absolutely.
I put our contact details for the duty lawyers there.
And that will come out in the email.
Right. And so the main thing for you to know, though, is this slide, which is how to access general legal advice. Law Access is our intake point. They will help you find the right kind of lawyer, the right team of lawyers, whether it's family law or any other kind of case. So those are the important points for how you can help a client get legal advice.
I might just jump in and plug my team, the wonderful CLE team at Legal Aid. So Shada has actually done a webinar with our team before during Law Week, and that was parenting arrangements and the law. And so that really was a foundational webinar to this. So it can, give you more understanding of the area of law. Before we do go, just a couple of quick reminders. A feedback survey will pop up right after the webinar. We really, really appreciate it if you just take a small amount of time to share your thoughts. It'll also come out in an email as a survey link. And again, I think I've said it about 5, 6, 7 times. We will send you an email with some important resources. And there are a couple of questions that we haven't got to. Not very many. They were, Shada, you really thought about this. So I just want to thank you.
The other questions I was
so
just going to say, people have said, can people start dealing with things? I think there was one here just saying, can people start dividing property before they get divorced? Yes, absolutely. They absolutely can. It's just that time limit runs at the end. So if you do it before, that's not a problem. And when parenting orders are drawn up at the kitchen table, they can still be used as a legal document. Not really, unless it's formalized, unless it's actually made legal, it doesn't count. So I think there are a lot of times where really what people need is to get their individual legal advice. So contacting Legal Aid or other legal services to get that advice is really essential. But having you here join us today is just so helpful for you to be able to help support our clients all together.
It is. And stay in the loop with our upcoming webinars, training. Make sure you subscribe to the Legal Aid New South Wales community, Workers Alert. Listen to top podcasts, find out about upcoming events, stay connected with us, stay informed. But big thanks to Sharda. Thank you so much for sharing your expertise. And we're right on 101. We've got some claps. Thank you, participants. Thank you, attendees. We really appreciate you turning up during your lunch hour and joining us. And we hope to see you again soon. Take care and see you for next session.
Thank you.
Bye.